You may begin.
May it please the Court, my name is Desiree, and together with my co-counsel Gabriel Salazar, we represent the respondent, the state of Atlantis. Atlantis is confronted with high rates of poverty, social exclusion, and an acute energy crisis, leading to its dependency on foreign energy sources. The state must react right now, and therefore the Black Swan hydroelectric power plant needs to be constructed in the middle of the Chupunco region. Not only because this is the best possible location to build Black Swan, but also in order to improve the impoverished living conditions in the eastern region of the country. In the following 21 minutes, I will first like to draw your attention to the right to property and the right to life of the Chupanqui community. Second, I will address the right to humane treatment of the La Loma and the Chupanqui community. My co-counsel Gabriel Salazar is going to analyze the right to judicial protection, freedom from forced labor, and right to property of the La Loma community. We would further like to reserve 3 minutes for the Sue rebuttal. First, I will start with the alleged violation of the right to property regarding the Chupanqui community.
Counselor, can I ask you before you get into that, why do you think that the applicants are not presenting this case in front of the UN Human Rights Committee?
Thank you for this question, Your Honor. The Atlantis is part of the Organization of American States, and this is like the head building of the whole inter-American system, whereas the Inter-American Court is the highest standard where you can get to reach a judicial decision, and therefore the applicants chose to apply this case to the Inter-American Court of Human Rights. Furthermore, the state did not violate the right to property of the Chupanqui community. Article 21 of the Convention is not absolute and can be subject to restrictions.
You said in your introduction that this was the best possible location for this hydroelectric plant. So do you concede that there are other locations possible?
Thank you for this question, Your Honor. There was a feasibility study done about where it's the best possible location to build this hydroelectric power plant. And the court should bear in mind that Atlantis has a lot of high mountains and significant river basins, and therefore they considered this place because the Shoshone River is one of the main rivers.
When we're talking about best possible location, are you then merely talking about factors, technical factors, or did you also factor in human factors, like maybe people that are living there, and the effect that it has on their living environment?
The state did indeed consider all these factors in his environmental and social impact assessment study, where not only the environmental impacts were assessed, but also the social ones. And in this case, of course, the Chupanqui community was affected because they had to relocate 35 kilometers away. But as the court said in the Saramacca case, the right to property is not absolute, and therefore they can restrict this right if the state does comply with the safeguards, which are the effective participation, the benefit sharing, and the environmental and social impact assessment study.
But should we still maintain then that this is the best possible location?
Yes, this is the best possible location for this type of hydroelectric power plant, because the Shoshone River is one of the main rivers in the country, and there was a feasibility study conducted to investigate if this is the best location, and that was the result of this feasibility study. Furthermore, a valid restriction must be lawful, necessary, proportional, and with the aim of achieving a legitimate objective in a democratic society. Additionally, in the case of indigenous land rights, the restriction must not result in a denial of indigenous traditions and customs. In order to respect the survival of indigenous traditions and customs, 3 safeguards must be fulfilled: the effective participation, benefit sharing, and the conducting of an environmental and social impact assessment study. The construction of Black Swan is necessary for Atlantis to alleviate the chronic energy shortages and the high electricity prices. The relocation of the Chupanqui community was proportional, since there were no other means to interfere less. Equally important is the state's legitimate aim of eradicating extreme poverty, producing clean energy, and improving the electrical power service for the whole country.
Councillor, can you explain to me the difference between the right to consultation and the need to obtain free, prior, and informed consent?
Thank you for this question, Your Honor. As the court said in the case of Saramacca versus Suriname, and reiterated the Commission reiterated this in the application for provisional measures in the Ngobe versus Panama case, the state always has a duty to consult if indigenous peoples are affected. The duty to consult is a duty where you have to, it must be an ongoing process, and therefore the state has a duty to consult with the community according to their customs and traditions. And consultation is not a single act, but an ongoing process of dialogue and negotiation. On the other hand, the free, prior, and informed consent, which was considered as well in the Saramacca case, does mean that it's only necessary when there is a project which can be considered of large scale. And in our case, we have the Black Swan hydroelectric power plant, which cannot be considered to be a large-scale development project because of its impact on the lives of the Chupanqui community. The distinguishment must be made with the impact, and as long as it does not constitute in a denial of the traditions and customs, there cannot be considered, restrictions are still possible and valid, and therefore Atlantis met, of course, all the general expropriation requirements and also the additional requirement for indigenous peoples that the restriction must not result in a denial of indigenous customs and traditions.
And Councillor, if you're saying that the duty to consult is an ongoing process, does that mean that even if you have your initial consultation, as we do in this case, the state is under an obligation to continue to have a dialogue with the indigenous group, including particularly when they decide to withdraw their approval from the project, as in this case?
Thank you for this question, Your Honor. The court should bear in mind that as the court decided in the Saramacca case, and also the Special Rapporteur, the United Nations Special Rapporteur James Anaya said, this whole consultation process must be conducted in good faith from both parties, not only from the state. And it must be conducted in a confidence-building manner. So in the end, the aim of this whole consultation process is to achieve agreement between these two parties. And this agreement has been achieved during 4 different meetings with the Intersectional Committee and the indigenous community, where also Rapstani language interpreters were present, and therefore this whole consultation process was conducted legally and it was valid. And
Councillor, but you say it's a negotiation. Don't we need for negotiation equality between the parties? And was that equality present in this case?
Thank you for this question.
From the very beginning till the very end of the consultation.
Thank you for this question. It was always, the state always respected the indigenous rights and also applied these safeguards which are necessary according to the court. And therefore they were always sensitive again, to the indigenous special relationship they have to their land, according to the Mayakna and the Yakia Aksa and Savoya Maxa case. And therefore they consulted with the representatives chosen from the community, in our case the Council of Elders and the main heads of households. So they respected their own indigenous cultural and identity by consulting with the appointed representatives from the indigenous community. And as well, we have to bear in mind that there were Rapstani language interpreters present, so they must have understood this whole process, and they were also informed about the possible risks on this project, which will have an impact on their lives. But in this case, this environmental and social impact assessment study only was conducted through the Green Energy Resources, and this is an independent organization of the state, which only said that this project...
Councillor, but a negotiation implies a fair and open dialogue between two equal parties. Was that present in this case, yes or no?
Yes, this was present in this case.
How do we know that from the facts?
We know that they were consulted before the construction of the whole project, and that they were they had acted in good faith, the state and the indigenous community, and they were informed about the benefits. They should have known about everything because they were the Rapsari language interpreters. So there must be an equal basis between these two parties.
Counselor, in the Saramacca case, didn't the Inter-American Court require that the environmental impact assessment study be performed before the granting of the concession? And was that the case in this particular case?
Thank you for this question, Your Honor. This case from the Saramacca case, where the court said that the environmental and social impact assessment study must be conducted before concession, must be seen only in particular through the case of the Saramacca versus Suriname case, because this case was about a timber logging concession granted to a third-party company, which also denied their means of survival of the indigenous community, because timber logging was an essential part of their subsistence, and this was taken away from them, and therefore they wanted to have this concession before. And in particular, we have to bear in mind that the purpose of this whole environmental and social impact assessment study is to protect and to preserve the special relationships of the indigenous community with their lands, according to the Mayagna, Yakya-Aksa and Savoya-Maxa case. And this was in our case always done because the environmental and social impact assessment study was done before the construction started, and this whole impact assessment study was only favorable to the project because it was the report said that black swan would only cause minor geological damages in the ecosystem and produce some sedimentary deposits in the water that are not harmful to humans. And additionally, this impact assessment highlighted the benefits derived out of the generation of electrical power. And the study recommended to secure the direct access to the river, which was done by the state because they secured their direct access to the Shoshani River. Furthermore, the impact assessment was conducted by an independent and technically capable organization under the state supervision. And regarding the effective participation,
Counselor, how can you make the argument, though, that this project isn't going to negatively impact this group's customs and traditions? You're taking them far away from the river. You're denying them access to the lands which are their ancestral lands. So how can you say it doesn't negatively impact them?
Sorry, if I can add that, what are the measures you foresee to make sure that their rights are preserved? Because you're saying it's very important for you, indigenous rights. So if you expropriate them, how are you going to make sure that their rights are truly respected?
Thank you for this question. The state does provide the indigenous community of the Chumpangi community with a direct access to their river, where they can maintain their cultural bond. Of course, there is an impact on their lives because they will be relocated 35 kilometers away in order to build Black Swan. But these 35, the Chumpangi community was aware of these 35 kilometers, and they agreed on this project because after this whole consultation process.
Sorry, I thought one group agreed but then withdrew their approval.
They did withdraw their approval later.
Later, yeah, after the consultation process ended. And therefore, the state was always aware of their maintenance of their cultural special relationship with the river because they had still the access. They did not remove them to somewhere where they could not even reach the river. And the Chumpangi community was at all times aware of these 35 kilometers because they were consulted properly.
But Councillor, can you expand a little bit about what my colleague said about the fact that actually that withdrawal has been rescinded? So how can you continue to say that they agreed to it?
The consultation process was conducted with, as I said, within sectoral committee and the Chumpangi community. The community decided to withdraw their consent to the project after other issues arose between the Chumpangi community and the Turbo Water Company, which was appointed to conduct the whole construction process. But in the beginning, they approved phase 1 and phase 2, and it would be it can be considered to be against good faith if they just change their mind after a correct consultation process was conducted
Can
and
be
it was valid.
considered, or it will be considered against good faith.
It will be considered
And do you
against.
have
Do you
any
ju- case
authority
law?
for that?
We have that the consultation process must be conducted in good faith. This was said in the Saramacca case, and also the Special Rapporteur James Anaya said that. And there must be some end to this consultation process.
In those
If not-
cases, whose good faith are they talking about?
In the case of the Saramacca, this was good faith. Well, the good faith must be from both parties, from the state and from the indigenous community.
So the indigenous community would never be allowed to come back on their opinion maybe once they got a bit more facts about the case.
We have to distinguish between two different situations, because this project cannot be considered to be a large-scale project. There is only a duty to consult.
A large-scale project for whom?
For the state and for the Chupanqui community.
For the community, it's a pretty large-scale project if they're moved to 45 kilometers from their ancestral lands. Wouldn't you say so?
Well, according to the Saramacca case, a large-scale project is be considered, it depends on the impact on their lives. And the impact on their lives, of course, will be the relocation 35 kilometers away, but they were offered also a good agricultural land to maintain their culture, the cultivating of their lands. And
But
also
one of the special features of an indigenous community is their relationship to their ancestral lands, not to their replacement lands. So wouldn't you say that it's a pretty large-scale project for, at least for their feelings, if they're relocated from their ancestral lands? You're breaking that unique link with their lands.
The state is very well aware of this special relationship with their lands. Because of that, they conducted a valid consultation process with them, and the fact that the community agreed on this project must be considered, because they were aware of the 35 kilometers away, so they knew they will have an impact on their indigenous traditions and customs. But they were aware of that, and therefore they decided to approve the project in order to receive the benefits of this project, which are the good agricultural lands, the electrical
Sorry,
service.
Council, instead of relocating them 45 kilometers, why did you not build your plant 45 kilometers away?
Thank you for this question, Your Honor. The state cannot build this plant somewhere, cannot build this plant 35 kilometers away, because they have to be on the river itself because of this hydroelectric power plant. And there was this feasibility study where they said that this is the best possible location to build because of the alteration of the river in this place, and also because of the whole landscape in this area. This was considered to be the best possible location, and therefore we had to relocate from the indigenous community 35 kilometers away. But they were offered the benefits, which are, as I said, the good agricultural land, the electrical services, and also their direct access to the river, and 8 water wells and free computers. They were offered all these in order to share the benefits with the construction project.
Free computers?
Yes. But we
Sounds weird to me.
the computers can be seen as a means for the indigenous community, for example, also to maintain their language, because due to have electricity and computers, they can maintain things, language.
Councillor, but do
programs.
these indigenous people, do they want
Yeah, do they need
computers,
it?
or do they want
Their land.
their land?
We have the court should bear in mind that the computers are part of the benefit share. It's not the only element. In order to maintain their culture, they secured their direct access to the river, and they offered them also the land. The computers are an additional benefit from the state, which they don't have to accept these computers, but this could be of could have a positive impact, for example, to maintain their own language. and therefore the state also had this benefit sharing in the country. And to summarize, the state fulfilled all three mandatory elements: the effective participation, the benefit sharing, and the conducting of the environmental and social impact assessment study.
But Councillor, when you were doing this consultation process, isn't it true that you didn't consult with the women of the Chupanqui community? So how can you say that you had an effective consultation process?
Thank you for this question, Your Honor. According to the Saramacca case, the state has a duty to consult with the representatives chosen by the indigenous community itself. And in this case, this is the Council of Elders and the main heads of households. So the state is aware of the fact that they have to be sensitive regarding gender aspects, but they acted according to the Saramacca case, where the court said that the state has to consult with the appointed representatives according to their customs and tradition to preserve their cultural identity. As I see that my time has run up, can I briefly conclude? To conclude, the state respected the right to property of the Chupanqui community and met all the requirements which apply to indigenous people. The Chupanqui community was not denied of their survival by the construction of Black Swan and were duly consulted by the state through its intersexual committee. Furthermore, the Chupanqui community members were neither arbitrarily deprived of their lives nor prevented to live in dignified living conditions. Finally, the state of Atlantis did not violate the right to humane treatment of the Chupanqui and the Laloma community, because the alleged violations did not reach the level of severity to constitute inhumane treatment. I will now cede the floor to my co-counsel Gabriel Salazar. Thank you.